our YouTube channel. All right, so yeah, I'll pass it over to you, Sandy. Thank you.
All right. Thank you so much, Torin and Stephen and the rest of you all for having me. I'm a longtime member of the IDRA listserv, although mostly a lurker. So I profoundly appreciate all of the work that you all do and the shared wisdom on the listserv. I'm very happy to be able to participate. I hope you guys will all forgive me. I'm a tiny bit under the weather, and I also have not been immersed in this project for the last 6 months. So I'm planning for this to be a pretty informal presentation. I'm going to share my screen and do a little PowerPoint, but just bear with me if there are things I don't remember. And my plan is to do the little PowerPoint talk for 15 minutes and then have a conversation. I also right now will put in the chat the white paper version of our article. So let's see if this works. Okay, hopefully now in the chat is a PDF, which is the white paper version. It's considerably shorter than the published law review article, although you can look that up too if you want. And feel free to skim that while I'm talking. So I will now share my screen. Okay. Torin, you guys see that? Okay, great.
Looks good.
So this is a project called Systemic Failures to Appear in Court. It is a law review article now published in the Penn Law Review at the end of last year. You can find it online on SSRN or the Penn Law Review site. And I am one of 4 co-authors. My co-authors are Lindsay Graef, who just finished her PhD in criminology here at Penn, Aurélie Ouss, who's faculty here in criminology, and Megan Stevenson, who's at UVA in the law school, faculty at the law school. The other 3 are real quantity people. They are trained economists, or at least trained in econometrics. And I am not. I just have a JD. I was a lawyer. I used to work with Nate Fennell, who's on this call. It's such a pleasure. So this is a joint project, but I am not the one who collected the data and ran the regressions. That is a caveat to what is going to follow. Let's see. All right. So the motivation for this work, my co-authors actually had been doing a bunch of data work in Philly. Lindsay, or rather Megan and Aurélie for years past, and Lindsay more recently. Lindsay Graef for her PhD actually spent 3 years embedded at the Philly DA's office. And that's through an ongoing partnership between the DA's office and a team of researchers here at Penn. And that's been phenomenal because just being inside the office physically has given Lindsay and other researchers a much deeper understanding of the data that they work with, what it actually represents, what it fails to represent, what the institutional dynamics are, what matters to people on the ground. So Lindsay was there at the DA, and the 3 of them were doing a bunch of data work. They were doing work around pretrial outcomes, rearrest and failure to appear, FTA. And as you guys all probably know, usually in the public policy discourse, when you're reading about FTAs, you're reading about defendant FTAs as a pretrial outcome for defendants on pretrial release. But looking at the data, the real story is just looking at the data, it leapt off the page or the CSV chart or what have you, that the people who really weren't coming to court weren't defendants. They were witnesses, especially cops and victims in, especially DV cases, but really in all cases. And they mentioned this and asked if I thought it was interesting and relevant. And I thought it was extremely interesting and relevant. And so we started looking into things further and eventually put together what is really just a simple descriptive project. It's just here's a thing that is happening that people haven't been paying a lot of attention to. I and my co-authors have been pretty deeply involved in bail reform stuff, advocacy work and research and lawyering. So we are, we've been involved in all the debates around FTA and how the system should respond to defendant FTA. This is one of the themes of the bail reform conversation. If we get rid of cash bail, defendants are never going to show up to court. And then you have all the great research that some of you on the listserv have done showing that much less intrusive interventions like text message reminders can dramatically increase FTA rates. So that's all well and good. But there hasn't been a ton of attention to the fact that the rationale for restricting defendants' liberty to get them to court is that we need the justice system to function. It's the effective administration of justice. We also need other people to come to court for the effective administration of justice. So we looked at the data. First question is just how frequently do people, actors who are necessary to the progress of a criminal case, but who are not defendants, fail to appear in court? The data itself came from a couple of different sources. One, the AOPC, the Administrative Office of the Pennsylvania Courts, have docket entries. These are the minute entries entered by the court clerks. They're not very detailed, but they do have text. So you can see kind of examples of those minute or docket entries at the bottom. And Lindsay, not me, you wrote really fancy code to run text searches and identify all these different words and combinations of words that indicated that a critical party to the case failed to appear. So only when, what we were looking for were instances where a case did not proceed, it did not go to trial, it was either continued or dismissed, and the docket entry indicated as the reason for that there was an FTA. We excised all the diversion cases because we didn't have complete records. It just gets messy. And those were about 12% of the total. So that is a limitation that we don't have those cases. And then other sources of data were, we had access to all the officer subpoenas, but only after 2017 issued by the DA's office. So I guess the other main source was the DA's internal data system. And right, as in many cities, you might think there would be one integrated data system for the whole criminal justice system, but you would be wrong, right? There's the court system, and then the DA has its own case management system with its own data, and then the DA has its own system, and the police have their own system. So we had access to the court data and the DA data. And on the DA side, in their system, we had, again, officer subpoenas issued after 2017, and the way we could identify if there was a victim or witness associated with a case was if there was information about a victim or witness sort of entered in the data fields in the DA's system. Okay. For the court data, we had data from 2010 to 2020. If anybody has a burning clarification question as I'm talking, please feel free to put up your virtual hand, and I think I will see it. And if not, maybe Torin, you can flag it if somebody has one. Great. Okay. So first big point, you look at the whole universe of cases adjudicated between 2010 and 2020 in Philly, and where the denominator is cases, non-defendants are way more likely than defendants to FTA. If there was a critical non-defendant FTA in 53% of the total number of cases over this time period, whereas in only 19% for defendants. So if your perspective is a systems perspective, and the question is, what is the bigger obstacle to the smooth administration of justice at a system level? it's not defendant FTAs, it's everybody else FTAing. And by everybody else, I should say, I mean witnesses and private lawyers. Prosecutors and defense lawyer or public defenders don't FTA. We can talk about that more if you want. Our supposition is they can substitute for each other much more easily. By actor, here are the rates by actor. So looking again at the entire universe of cases, each other category of court actor, they have FTAs in approximately as many or more, except for the defense lawyers, right, of the cases as defendants. But again, we're looking here at the universe of all cases. Now, all cases require a defendant, but not all cases require a police officer. Not all cases require a victim. So you might, to get a more kind of apples to apples comparison of FTA rates by actor, you want to look at only those cases where the relevant actor is required to appear. This chart just shows that different case types require different actors. So DV cases generally in our sample, right, as stands to reason, have a victim associated with them. And drug and DUI cases typically don't have a victim associated with them, but they do have and require a police officer. So what we then did was separated out for each court actor the universe of cases for which that court actor was required, and looked at FTA rates in those smaller subsets. This chart shows the FTA rates by actor only within the group of cases where where they're expected to appear. And if you break it down like this, for the group of cases where that actor is required, the FTA rates are significantly higher for every other category of actor than they are for defendants. So in cases where a defendant is required, the defendant FTA rate is 19%. In cases where a police officer is required, the police officer FTA rate is 30%. In victim, it's 47%. Other witness, it's 46%. Private defense attorney, it's 36%. By charge, this is victim FTA rate by charge. The really shocking, maybe it's not necessarily shocking if you've worked in a court system, especially a low-level criminal court, but I think it is shocking if you haven't. Right? In 69% of DV cases, a victim fails to appear at least once. I should say all of this is at least one time. And then here's the police officer hearing level chart. Okay, so another way you might want to break it down is by hearing. And we couldn't do this for every court actor, but we could do it for police officers because we had the subpoena data. So this is 2017 to 2020 at hearings where among all of the hearings where a police officer is expected to appear, police officers FTA, 13, I think is that 13% of the time, something like that. 14% of the time, defendants only 7. The police thing is disturbing because police, not only do they have a typical witness, legal duty to obey a subpoena and appear in court, it's also part of their job, and they're the ones who started the whole proceeding. So, the paper gives some extended attention to police FTA. If you break it down by charge type, this is what it looks like. Now the DV, it looks like, oh, police almost never FTA in DV cases. that figure, that statistic may be misleading. So recall that the way we're identifying FTA, we're identifying FTAs identified in the court docket entry as the reason for a continuance or a dismissal. In DV cases, and in speaking with prosecutors, we understand that cops FTA all the time in DV cases, but because the victim is so central to the case, if the victim FTAs, that's what will go in the docket entry, right? The cops aren't necessarily essential, and the court clerk is just not noting officer FTAs in the same way. So that might just reflect the lower frequency of annotation rather than an actual lower frequency of FTA. On the other hand, drug and DUI cases, those really rest on the testimony of police officers. And so there's a much higher frequency of police FTAs that have consequences for the progress of the case. Now, as I've been alluding to, the reason that FTAs matter is because they affect case processing, as you surely know. If a critical witness fails to appear, the case can't proceed. It'll either be continued or dismissed. And indeed, if you look at the universe of cases in our data set, the dismissal rate was 25% approximately for cases where there was no critical witness FTA, and 50% for cases where there was. Sometimes, I guess, typically when that critical witness failed to appear. Now, we can't really do a robust causal inference here. So this is just correlational, but there's good reason to think that the FTAs are playing a pretty important causal role in that difference in dismissal rate. And what we could do is control for other visible variables in the data. And among all the visible variables in the data, witness FTA is by far the strongest predictor of case outcome. It's more predictive than all of the other factors in the data combined. So what are the implications of all this for policy and criminal justice reform? First of all, if we actually, if FTAs are a problem and we want cases to proceed and justice to be administered predictably and efficiently and smoothly, then we say in this paper, we really have to think about them as a systemic phenomenon. This is not a problem that is unique to defendants. It is a much higher level, more universal issue. And a lot of the reasons that defendants FTA are also reasons that other witnesses FTA. We can maybe talk about this more in the Q&A, but just the logistics of getting to court and being in court all day, as you often have to be for a case. I think the logistical barriers and the administrative dysfunction drive a significant portion of both defendant FTA and non-defendant FTA, and should be amenable to shared solutions across the board. Right. Secondly, and relatedly, the systemic nature of FTA calls into question some of our bail practices, the extent to which we restrict defendants' liberty on the grounds of non-appearance risk, when we don't think that is a sufficient ground to restrict the liberty of witnesses for the most part. Then there's also the normative stuff. Is FTA on this scale a problem? Is it always a problem? Is it sometimes a problem? In DV is a really interesting and difficult arena. Sometimes, if the reason that victims aren't showing up is because they're being threatened or coerced, that seems very bad. On the other hand, if the reason that victims aren't showing up is because it wasn't as serious a conflict as the system has portrayed it as, and this, prosecuting the case isn't going to make anything better, this isn't the right response to the problem, then maybe it's a good thing that witnesses aren't showing up and cases are getting dismissed. It seems reasonable to think victims should have some autonomy and maybe some control over the process. Anyway, these are just a few of the issues and questions that these data raise. And I think I will stop there and let's talk.
Yeah, so please do feel free to unmute. We have a a reasonably sized group here, but also feel free to raise hands and we can work it out that way. I definitely have questions or things to bring up.
I do too.
Oh, okay.
Like one thing,
Please.
one question I have for the group is, a challenge we had with this paper is it's Philly, it's based in Philly. We didn't have data for other places and we don't really know how representative it is. We did some kind of informal polling of our friends and colleagues in other jurisdictions. But I'd love to hear from you all to what extent it seems like it might, like your jurisdiction might have similar dynamics or not.
I think that's a great question. I have no answer for it. I'm too far away from the data, and we don't have great data in Indiana. There might be specific cities that could answer, but I'll open that up to the group. Yep, please go ahead.
Hi, Sandy. This is Steve Saloom. I don't know if we've met before when I was at the Innocence Project, but perhaps years ago. In any event, thanks for this. I'm at Unwarranted now at Ideas 42, and so we work on the text reminder programs and reminder programs in general.
Awesome.
And I've got a question for you. Are you aware of systems, I guess akin to those, conceived of for defendants that work for other actors, or even just existing systems and how they could be applied to that? I'd love to hear more.
Yeah. The short answer is not really, but I would like to be. So, and the longer answer is the DAs here in Philly, were particularly frustrated at the lack of what should be very available technology to contact people. So, one among the many dynamics that fuels the police officer FTI here in Philly is that because of scheduling, the DA's office is under pressure to try to schedule all of as many hearings as possible for a given cop on the same day. Right. So if you, Steve, are, you have a whole bunch of cases, the DA, I'm supposed to try and schedule all of your cases for the same day or different DAs. And that results in each cop having like 15 subpoenas for different courtrooms on the same day. And it happens all the time that a police officer will be testifying in one courtroom, needed in another courtroom, and there is no way apparently to communicate the fact that he is in the courthouse and will be available in 15 minutes. And so the DA, who is the chief of municipal court, which is our misdemeanor court here in Philly, is like, my Thai food has better tracking than the police officers I need to put up my cases. Like, why do we have no system? So there's that anecdote here. And then the other interesting anecdote from Philly, from the prosecutors here, was there is a new text system for victims, for DV victims, that was implemented as a result of some state legislation requiring more notice. It was I think like a Marcy's Law thing requiring more notice to victims of different stages in the criminal case. So they set up this text system. And the DA's experience, just anecdotally, has been that the victims now get so many texts and they're so confusing that they just like block texts from the court. And then and stop answering calls. And it actually has perversely made it harder to contact the victims because
Yeah.
that those are sheer anecdote.
Mhm.
I am unaware of a jurisdiction that has implemented a really effective, text and email reminder system like my dentist does
Mhm.
for victims and cops and
Mhm.
witnesses, but I'd love to know if one.
Yeah, yeah, and I don't. Hopefully soon I may. But I guess just a quick follow-up. Do you think court systems, court administrators, stakeholders would be amenable to kind of, I hate to suggest the task force or the commission or
Yeah,
whatever, but given the seeming impact, obviously on case dispositions, but also just backlogs, I would
yeah,
imagine.
yeah.
And has anyone, last question will be, has anyone, so it sounds like, yes, they probably might be amenable to talking about this in jurisdictions. Does it seem like a problem they care about?
Yeah, I would think so. I mean, that's part of why we wrote the paper. Like
Yeah.
this, part of this seems like a problem we can solve, we're starting those conversations here in Philly. I mean, one thing that has happened, to my knowledge, this is my understanding. If anybody on the call knows more than me about Philadelphia, please correct me. But another thread in the paper with respect to police officer failure to appear is that there had been zero discipline method. There's like just zero accountability for officers in
No.
court. Yeah, I know. Yeah, shock. But the new chief here has reportedly implemented a new process to track officer FTA. So that's positive. And the court administrators do seem interested. It's just a matter of making it happen. We still, here's another thing that contributes to cop FTA here in Philly. Half of them get their subpoenas from a fax machine in City Hall it prints out the subpoenas, and then there's one person whose job it is to like walk around and hand them out to the supervisors who are supposed to then give them to their officers. Like, surprise, surprise, that doesn't work all that
Yeah,
well.
right. Yeah.
When the fax machine breaks, nobody gets their subpoenas. So just the practical,
Yeah.
non-sexy logistics of bureaucratic management are
Yeah.
an obstacle.
Thanks a lot for all that. So
Thank you.
yeah.
One thing that I wanted to bring up, it's not even really a question, but just something that isn't mentioned in the white paper that for me was like seemed crazy. And please correct me if I'm, because it's been a bit since I read the paper, but you also looked at failure to appear for defendants in custody versus
Yeah. Oh,
out of
yeah.
custody, and
Yeah.
it was worse for defendants in custody, or was it about the same?
No,
Okay.
it's not worse, but it's not trivial. I think it was something like 7% of.
Okay.
Oh, I need to find this.
Sorry, I didn't mean to like take you off guard, but that
No,
was crazy to me, like that was even a thing that could happen. But
yeah. So for purposes of like bail reform rhetoric, I do think this is helpful that we think of pretrial detention as like the thing that can eliminate the risk of failure to appear or rearrest, and eliminate the risk of failure to appear because it's quite routine that people aren't brought down or over wherever people are brought from for court. At least in Philly and New York, there was recent reporting about FTA rates among defendants on Rikers. It was something like 1 in 4 defendants weren't being brought for their cases because of instability, crisis in the jails.
yeah, that's crazy to me. And then that kind of leads into the other question. You've talked about this a little bit, but have you heard from and it sounds like you're definitely in communication with the DA's office, but like any other decision makers, like are judges, like is this changing views on pretrial detention? Or I mean, obviously there's interest in like these fixing the other problems, right? But
Yeah.
it also, as you say, really highlights the like what do we detaining these people for if this
Yeah.
isn't working and
Yeah.
there's all these other problems we need to solve first.
Yeah. There's everything is interrelated and dynamic, as you all know. So in Philly, thankfully, I don't think we are detaining anyone pretrial on the basis of appearance risk at this point. I think, Larry Krasner is our DA, and there had already been efforts underway to shrink the jail population that his office has furthered. So at least for the moment, I mean, I'm not saying it's ideal, but at least for the moment, the people who are being held on dangerousness grounds, and for detainers of various kinds. But as to the judges, so this is something I want to pursue. In all my free time, is sort of practical follow-up and policy change. Judges are amenable to administrative changes that will make court function better, but one of the really difficult dynamics that contributes to the FTA rates, and now let me just speak for myself, right? I'm not speaking on the basis of data, no rigorous econometric analysis here. This is my impression of court here in Philadelphia and in New Orleans, where I used to work. Court's scheduled around judges' convenience, and that makes it hard for people. Like, judges come late all the time. We toyed as we were doing this project with whether we could do a judge FTA. How would you do that? Because there is no, there's no court clerk doing minutes when the judge is not there. Court doesn't start until the judge gets there, and it is quite regular here in Philly, and it used to be in New Orleans too when I was there, for people, like a whole courtroom of people, to be sitting there for hours waiting for a judge to show up. So one of the things that you could conceivably do to reduce FTA rates and make it easier for people to get to court is more accurate and precise scheduling, the way that doctors' offices do. But I think that would be a lot harder for judges, and they don't want to do that. So there's not, it's complicated.
Yeah. Again.
Oh, go ahead. I just left it. It's like,
no, I was gonna say, please, if you have other stuff you want to talk about, please do.
I was just gonna repeat my call. If any of you guys have a strong reaction, or even a lukewarm reaction, like, oh yeah, this is totally how things work in my jurisdiction, or oh wow, that's really different in our courtrooms, police officers never FTA and witnesses are generally there, I would love to know. Or if any of you know of more effective systems for getting people to court.
Yeah, that was going to be one of my questions too, was like, if because so I did ask around here, but like I don't work with, I'm so far removed from the people that are actually doing this work, and I got like some skepticism that like I don't know that that's how it works here, like or like I like specifically for like the people coming over from the jail, someone said like, oh, I don't remember that happening very often, like failing to show up. But I also am very skeptical of, well, so I guess, did you, before you started, like, did the actors there even realize that this was happening? Because I feel like if you're in it, like,
totally. Yeah. So this is this is a something I think about a lot, the disconnect between practice and academics and research, right, and data, is this, I think we say in the paper, like, this is the air they breathe in court. Of course, people who work there know that witnesses and cops often don't show up. It's every day. And if you go to the misdemeanor court, especially, it's a little bit different in the felony court, but in municipal court, which is the language is so different place to place. Municipal court here is a state court for state misdemeanors. And in Pennsylvania, misdemeanors are punishable by up to 5 years. So I say municipal court, it sounds like what in other cities are very, very low level courts for municipal offenses. It's not that. It's court where offenses punishable by up to 5 years are tried. And also felony preliminary hearings are held. So in that court, in any given courtroom, every day there will be 30 to 40 cases on the docket, and 1 to 3 will go. And the rest won't go because somebody essential isn't there. And, usually it's not the defendant. It's either, I should say, it's either because of an FTA or because of a discovery problem. There are lots of discovery issues that hold cases up, but, one or the other. So I send my first year criminal law students to municipal court and my seminar students, and they write little reflection papers. And every year, one of the themes of the reflection papers is like, where is everybody? Why isn't anybody there? Why don't the cases go? Yeah. So yeah, absolutely. People in the system knew it, but it's so much taken for granted that it's not something that gets out into the world of people studying criminal law unless you go into court or the DA's office or like really look at the data, I guess. I'm always curious what else we're missing, what else we academic and data folks are missing that's just like essential to the reality of practice.
It looks like in the chat. So Paul Lovelace, who's worked in a couple counties in Arizona, said he hasn't seen data but has heard of similar problems. And then Leslie, who's over in Utah, brought up interpreter FTAs as being an issue over there.
That's
which
interesting.
I don't remember. That wasn't discussed in the paper.
No,
okay.
No, not at all.
But yeah, that is definitely that seems like it's going to become an increasing issue.
Yeah.
Yeah.
I don't think we have enough cases that require interpretation for it to show up as a category, but that's fascinating. Yeah. Anybody? We don't have to talk longer than you guys want. It's not a complicated paper. It's a here's the thing that's happening paper. When you're talking about FTAs and thinking about FTAs, maybe let's think about them in a more holistic way. The other area in the paper that feels very shallow to me, and where I wish we knew more and had more to say is domestic violence. I think this is such a fraught area of the criminal legal system. And it's so obviously not working. I am not myself an expert on domestic violence, prosecution or defense or policy, but I hope that people in this community will pay attention to it. And if anyone is doing work in that realm, I'd love to hear about it. Especially this is a quanti empirical community. If anyone is doing any sort of empirical work on alternatives to criminal prosecution, I would really like to know about that.
So I had a thought that maybe is kind of tangential to this work. So I don't necessarily know if it's going to lead to a lot of fodder for conversation. But one thing I'm thinking about is how sort of pretrial bail decisions are made and sort of risk assessments take place. So I just remember that there was a big movement to try to create, more scientific, stats-based risk assessment instruments. And some of them were very proud of the fact that they were only about whether someone was going to fail to appear. Instead of including these other risk factors that might be more racially biased or, class biased, whatever it might be. But what that says to me, right, is if we're just basing it off of risk of failure to appear, then we need to start detaining cops, right?
Right.
So,
exactly.
Obviously I'm not saying, therefore, let's do that, but it is just so interesting to think about how people were saying, if we only focus on failure to appear, we can get these very scientific results. And your paper is saying, I have another angle actually on that, which I find, very, very compelling and certainly something to pay attention to as jurisdictions consider how they're making these assessments of people. Yeah.
For sure. A couple of points to add to that. I mean, first, just on the rhetorical moral dimension, I do love the fact about this paper that so much of the bail conversation is about pretrial outcomes and risk. It's that the moral undertone is, oh, we're dealing with a group of bad, dangerous, lesser people, and they're going to do bad, dangerous things. And that no, we're dealing with humans and an administrative bureaucratic system. And if you look at the other humans that interact with the system, they're going to do the same kind of thing. In fact, they're going to do it more. So yeah, the cops, FTA, way more. Some of it is for innocuous reasons, like the fax subpoena machine broke down. Some of it is really nefarious. Like there were cops, we interviewed a bunch of cops. And again, the interviewing process was not extensive enough for us to write it up as qualitative research, but we did do a bunch of interviews, and a couple of police officers told us that they or colleagues of theirs would sometimes skip court if they knew it had been a bad stop and they were worried about the cross-examination, right? They didn't want to be exposed as non-credible on the stand. Like that's really bad. And other times you have officers they don't think a case is really worth pursuing. They needed to arrest the person, but they don't think it's necessary for the case to make it all the way to adjudication. Like that's troubling. That means police are exercising unitary discretion over the enforcement of the law, and that the arrest and pretrial detention really are the punishment, right? The only punishment that the system is seeking to impose. So yeah, on the moral, rhetorical, theoretical dimension, there's some really interesting stuff here. Then I was going to say something much more pragmatic. Oh yeah, right, about risk assessment and FTAs. So yes, thankfully now I think everyone has recognized that a risk assessment instrument that just predicts pretrial quote unquote failure is kind of pointless and useless, because being rearrested for a aggravated assault is a very different thing than not showing up for one court hearing, a status hearing, because I don't know, you couldn't get off work. Like very different things, very different kinds of risk. You need to predict them differently. Great. So now we have instruments that predict them separately, and we have these risk scales for FTA. However, all of those risk assessments are designed, they're built, the models are built on the basis of data where the thing they're trying to predict, the variable in the data that is the target variable, is not actually an instance of failure to appear. It's the issuance of a bench warrant. That's how almost all the FTA risk assessment instruments are designed, so that the statisticians or the machine learning model, whatever it is, look at in the data instances of bench warrants being issued, or capious warrant. Like, okay, that's a failure to appear. Now, what other variables in the data correlate most strongly with that outcome? But bench warrants are not issued for every FTA. They are never issued for police officer FTAs. Never, ever, ever. So you couldn't train a risk model on the basis of bench warrants to get a predictor for a police officer FTA. It varies by judge. It varies by the kind of case, by the kind of defendant. And actually, I can tout the work of my co-author, Lindsay Graef, newly Dr. Graef. Another one of her PhD projects is an empirical analysis of risk assessment tools. And so I don't remember the details, but basically it's showing that using bench warrants as the basis for predicting FTA is really inaccurate. And I think it might be more inaccurate for certain demographic groups than others. That'll just be a teaser.
Well, and now you have a data set about police failure to appear, right?
Right.
So you could actually start asking more questions.
You could. We definitely, every time we present this, we get questions about can you predict it, and
Yeah.
can you
Do a
track it
risk
by
assessment of
individual,
cops.
right,
Yeah.
and by
Right.
individual officer. And that we did try to do for the data that we could do, and it was really interesting. There was a sort of a distribution with a really long tail of a handful of officers who were absolutely serial FTAers.
That's very interesting. Do you think that, well, so there's probably not enough data, but like, is that because of the kind of cases that they're doing, or do you think it's because those officers make bad stops, or do you think it's, or it could be any of those?
I am not myself intimate enough with the data, or I don't remember. I also don't remember,
Fair.
so I don't want to say things that aren't true. I don't remember.
Is there any plans to like do more with that in the future, or unsure?
I don't know. Honestly, not myself.
Okay.
I feel guilty telling this group I'm about to do a bunch of theory work, and so I am not myself going to be doing more empirical FTA stuff, but I hope that others will.
Yeah, I mean, we love the theory papers here too. We have a pretty wide range, so
Yeah.
but yeah, we are coming to the end of the hour anyway. So I think I'll hem and haw for a few minutes just to see if, or a minute to see
Okay.
if there's any more questions, or unless there's something else you wanted to bring up. Okay, well, thank you for coming. As you said, this I really like the white paper version, which I had not seen, because it really does just like it's one of those like punch you in the face results. I think like you're just like,
Yeah.
really, like this seems like I had no idea, as somebody who does not interact with the court system directly.
You know what, Torin, can I say
Yeah,
one more thing
yeah,
that I
please.
think?
You can say as many more things as you want.
I think this is, oh, and Bob Orshowitz is asking if the paper's available in the
Yes.
chat. Yeah,
Yes.
I can just drop here's the SSRN link, and then oh, is that the white paper that Steven sent?
Yes. So that's, yeah, Stephen just dropped the white paper.
And here's the full paper to, oh, one sec. To everyone. There you go. Right. I was going to say, I find it important. My co-authors don't think this is important, but I'm always afraid of that someone would attack our results or our presentation by saying, whoa, 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 you're talking about something different than we usually talk about when we talk about FTAs conceptually, because usually when we talk about FTA rates, the denominator is a group of individuals. We're looking at a group of defendants, and the rate is how many of those defendants fail to appear. So it's a sort of a rate among a group of individuals. And that's not what you're looking about. That's not what you're looking at. Sorry, you're looking at a group of cases. You're looking at all the cases where that actor is required. What proportion of the cases does that actor fail to appear? So that's true. And I just want to acknowledge that in case anyone is confused about that. It turns out if we do it by individuals, the numbers are essentially the same. For the most part, it's one individual per case. The way that cases are enumerated in the Philly data, it's by defendant. So it's one defendant per case. And I forget exactly how the math works with the cops, but it works out to be quite close. But that is a conceptual difference in how we're talking about FTA rates.
That's a great point. And definitely one that I had not really considered. Because it is a different and that's important to know if we're kind of comparing to our own internal numbers. But and then there are some questions in the chat about availability of stuff, and as Steven said, we're going to be posting this on the YouTube channel sometime next week or so, and I'll send an email out about that as well, in case anyone
Awesome.
wants to rewatch. And unless there's anything else that you want to talk about, I'll just say thank you so much for coming to present. Super interesting paper, as I've said several times probably.
Thank you all so much for joining. This was fun.
Yeah, thank you for coming to present, and we'll see you all next month for the next call.